Hello students, welcome to Epitome IAS. In today's session, we are going to discuss an important question. Probably it was asked in 2016 mains. Okay, right. What is quasi-judicial body? Explain with concrete examples. In fact, the same question has been repeated in the TPSC Group 1 also. Okay, so such kind of repetitions are highly possible. For example, in 2025 mains question, mains examination in the General Studies paper 2, there was a question on Attorney General of India. The same kind of question was asked in the 2026 mains. So that's why the themes of the UPS questions will be constant. The nature of questions will be changing from time to time. So we need to understand different dimensions of the same topic so that the recurring themes, the recurring dimensions can be better answered. Okay, right. So here, what is quasi-judicial body? Explain with certain or concrete examples. Right. First of all, before we understand what to write for this particular question, let us also understand what is the general importance of this topic. Okay, what is the importance of this topic actually? Right? Why this kind of questions are being asked? Reason is we have implemented LPG, liberalization, privatization, globalization through 1991 economic reforms. With this, we started implementing liberalization, privatization, and globalization. So after that, after these LPG policies, the role of the state is gradually declined. And we are able to see the concept called as minimum government, and maximum governance. So this kind of approach we are able to see after liberalization, privatization, and globalization. Right. So naturally, what the state has to do after LPG? The state is expected to be facilitator, So, and moreover, state is expected to provide regulation instead of control. Right? So this kind of theme we are able to expect in the context of liberalization, privatization, and globalization. So in other words, we are able to see minimization of the state minimalism. And in this context, the state must facilitate maximum liberty of the people. And at the same time, this will be giving rise to better business atmosphere. Okay. In this context, we are able to see innovative mechanisms or innovative institutions which can help in the redressal or which can help in the resolution of disputes in the country. Okay, so this is leading to better resolution of disputes. Generally, dispute resolution traditionally belong to the domain of the judiciary. Okay, so traditionally, we need to understand. Dispute resolution belongs to judiciary. Okay, traditionally dispute resolution belongs to judiciary, right? But however, the judiciary is showing a lot of lag, and there is nothing but delays. Okay, lack of expertise, in the discharge of its duties, or lack of technical expertise, we can say, okay, and a lot of formality or complexity in the dispute resolution mechanism. This led to the problem in the ease of doing business. So that's the reason why we started encouraging alternative dispute resolution mechanism. Okay. After that, we started ADR. Okay. Alternative dispute resolution mechanism. Okay. Right. So this ADR generally follows informal mechanism. Informal mechanism to resolve the disputes. Informal mechanism to resolve the disputes. And moreover, it became citizen-centric. Citizen-centric. And it addresses delays. And justice becomes cheap. The cost of the justice will be reduced. Just become cheap or cost effective. So this kind of impacts we are able to see because of adoption of different innovative mechanisms like alternative dispute resolution mechanism. And all these mechanisms generally establish the institution called as quasi-judicial body. Quasi-judicial body. Right. So this is what the centrality of the topic. Right. So in this context, let us discuss what is quasi-judicial body, and let us explain with concrete examples. Okay. Right. Basically, so in the introduction, we need to write directly the quasi-judicial body. Means quasi-judicial body means it is a non-judicial body. It is a non-judicial body, performing judicial functions. Right? Right. Performing judicial functions. And it is found in various forms. Okay, ranging from constitutional to statutory. Okay, so this is how we can write the introduction. Okay, ranging from constitutional to statutory. So thereafter, we need to write other aspects. Okay, right. The quasi-judicial bodies differ from the judicial bodies in various respects. Despite they also resolve the disputes similar to that of the judiciary. Similar to that of judiciary. So this is how we need to frame the answer. Okay, right. So later we need to write how quasi-judicial body is different from that of the judicial body. Okay, right. We need to write a table. Let us take a table to differentiate. Okay, quasi-judicial body versus judicial body. Quasi-judicial body versus judicial body, right? And then how do we write the difference for this? Okay, so first and foremost important point is, right, it is either constitutional or statutory. It is either constitutional or statutory. Either constitutional body or statutory body. Right. It is always a constitutional body. It is always a constitutional body. It is always a constitutional body. Then we need to write it follows only procedural substantive laws. Substantive laws. Okay. It follows both substantive laws and procedural laws. Okay. Right. Next. They resolve the disputes which are permitted by Constitution. They resolve the disputes which are permitted by the Constitution. Permitted by the Constitution. And coming to them, they resolve all the disputes except those which are excluded by Constitution, excluded by statute, we can say, statute or Constitution, statute or Constitution. Right. Next, number 4. It is client centric. Hence it provides cheap justice. Okay. It is advocate centric. It is advocate centric. Okay. So because it is highly complex, it follows both procedural laws and substantive laws. Generally, the substantive laws are those laws which help in the resolution of the dispute. Those are called as substantive laws. Procedural laws means those laws which will provide procedure. Substantive laws means those which are the basis for justice. Substantive laws are those laws which are basis for the justice. For example, if you have a contractual dispute, so the law is Indian Contract Act. If you have some marital dispute, the law is Hindu Marriage Act. Like that, there are laws which are the basis for justice. Those are called as substantive laws. Procedural laws means those laws will provide the mechanism to resolve the dispute, the courts. That is what called as procedural law. Generally, procedural law is highly complex. It causes delays. Okay, that's why see this particular tribunals, or we can say quasi-judicial bodies, will follow principles of natural justice. So usually their approaches, their mechanisms do not follow procedural laws such as CPC and Indian Evidence Act, etc. But they will not be ignoring the principles of natural justice. So this is how we can explain this. Okay, and usually appeals are not possible except when there is a miscarriage of justice due to unfairness. Due to unfairness. Okay. Here the appeals are usually possible. So this is how we can explain what is it, quasi-judicial body, right? So coming to the examples for this quasi-judicial body, too many examples actually. For example, so the quasi-judicial bodies mentioned in Constitution. The quasi-judicial bodies mentioned in Constitution. If you try to look at this particular point, so first one, Speaker or Chairperson with respect to Anti-Defection Act. Okay, so they are discharging the responsibility to disqualify a person for the breach of law. So that is nothing but quasi-judicial function. So they are taking action. Number 2, Attorney General, as per Contempt of the Court Act of 1971, where he can give the consent for the prosecution of a person, right? Then coming to number 3. Okay. So tribunals established under Article 323A and 323B. 323A and 323B. Similarly, President of India will also be having quasi-judicial function under Article 1 or 2 of the Constitution. Article 1 or 2, right? And 1 or 3. Okay. So this is how. Similarly, the power is also there with Advocate General as well, right? So coming to, we have various tribunals, okay, and even arbitration tribunals like Arbitration Conciliation Act of 1996, okay. Similarly, Mediation Act, okay. So these are all tribunals only, okay. So water disputes tribunal, tribunals that is created under Interstate Water Disputes Act, Interstate Water Disputes Act of 1956, right? Similarly, you can also see Lok Adalat. So it is also alternative dispute resolution mechanism, okay? generally the quasi-judicial bodies will be having purely non-judges, or it's a combination of judges and administrative persons. So the composition is generally in favor of executive. Composition is generally in the favor of executive, right? Or in the favor of generally non-judicial person also, right? For example, water dispute tribunal be having experts in the field of water disputes. Of course, it may be having judicial members, but still the technical expert more permitted to be applied in the case of resolution of disputes, right? So that is how. Okay. So in this way, we can explain what are the quasi-judicial bodies. Okay. So you can write any other example which is possible here, right? So this is how we have explained what is quasi-judicial body, right? Look at this. Okay. So we have written what is the meaning of quasi-judicial body. So judicial body forming a non-judicial body performing judicial functions. It is found in various forms ranging from constitutional body to statutory bodies. Quasi-judicial bodies differ from judicial bodies in various respects, despite they also resolve disputes similar to that of the judiciary. We have written the differences. It is either constitutional or statutory. It is always constitutional body. It follows only substantive laws. It follows both substantive laws and procedural laws. They resolve the disputes which are permitted by the Constitution. They resolve all the disputes except those which are excluded by the statute or Constitution. It is client-centric, and hence it can provide cheaper justice. It is advocate-centric, and usually appeals are not possible except when there is miscarriage of justice due to unfairness, and the appeals are usually possible. So quasi-judicial body generally mentioned in the Constitution. There are certain bodies which are mentioned in the Constitution, like Speaker, Attorney General, Chairperson of Rajya Sabha, Speaker of State Legislative Assembly, Tribunal established under Article 323A, 323B, President under the discharge of his functions under Article 102 and 103, Water Dispute Tribunals, Lok Adalat Tribunals, okay, Administrative Tribunals, okay, as well as Arbitration Tribunals, Mediation Act. So these are all the methods where we provide various types of quasi-judicial bodies in the country. Okay, so in the conclusion, thus the constitutional body, the quasi-judicial bodies, are created to ensure, resolve a particular dispute requiring technical expertise at the same time it provides a easy means to resolve the disputes. So quasi-judicial bodies are created to ensure resolve particular disputes requiring technical expertise. At the same time, it provides easy means to, or easy process to resolve disputes. Okay, and the powers of quasi-judicial bodies are provided and limited by the Constitution or statute. Okay, so this is how we can give a broader conclusion. Okay, right. So I hope understood what is the essence of this particular question. So if you have any queries, please post in the chat box provided, and kindly give your inputs, valuable inputs, in order to give you better information to the students. Okay, thank you. Have a nice Sunday.